Yes.
My Lords, I appear with Mr. Edwards and Dr. Yeh on behalf of B&D Claimant Chemicals Ltd, Defendants and Appellants. My learned friends, Mr. Kitchener, King's Counsel, and Mr. Wang appear on behalf of Water Ltd, Claimant and Respondents. Your Lordship will see this is a dispute concerning commercial water charges for an industrial property in Surrey, arising from an admitted spike in alleged consumption between July 2018 and July 2020. I can give the Court a brief procedural history. The claim proceeded to trial before the Deputy District Judge Ginesi on 21st September 2023, with judgment handed down on 27th November 2023. Put shortly, if I may, she found that the meter in question was, in her words, effective, that evidence beyond the statutory test can be relied upon by a customer, and that the Court is entitled to take account of that in assessing whether the meter was, again her words, effective. As a reference, her judgment can be found in the core bundle, page 183 forward. Castle Water appealed. The appeal was granted and the appeal proceeded before His Honour Judge Simpkiss at the County Court at Brighton on the 23rd of July 2024 last year. His Lordship allowed the appeal, set aside the order of the Deputy District Judge, judgment for Castle Water for a sum to be agreed. His judgment, the reference again, is in core bundle at page 113. A sum in the end was not agreed, my Lords, and His Honour Judge Simpkiss made a determination on the papers on 14th November 2024, core bundle 108 to 110. As we know, this is an appeal from that decision, and our amended grounds of appeal, 3 in number, can be found in the core bundle at 14 to 22. Yes. And the permission to appeal in line with the grounds of appeal was granted by Lord Justice Arnold in respect of all 3 grounds on 25th October 2024. And if I may, I would like to just look at that very briefly. So core bundle 102. Halfway down, His Lordship says, permission to appeal. Ground 1 has a real prospect of success and raises an important point of principle concerning the interpretation of Regulation 8 of the Water Meters Regulations 1998. Grounds 2 and 3 have real prospects of success because it is argued that the judge was not justified in overturning the Deputy District Judge's findings of fact, having regard, amongst other things, to the decision of the Supreme Court in Griffiths and Toohey. Alternatively, that he should have remitted the issue. Now, my Lords, I want to take the Court to that because an issue has arisen this morning as to whether the Toohey and Griffiths authority in the Supreme Court is properly in the bundle. I'm going to come to that very shortly. Okay. Lords, I mean, just go straight to the heart of the matter. In the dispute between the parties, it's simply how those regulations of water meters regulations 98, and in particular regulation 8, should be interpreted. They can be found in the core bundle, authorities bundle at page 12. And regulation 8 can be found at page 50. Now, the Lord, simply as an overview at this point, it is headed at Regulation 8, Method of Proof and Effect of Meter Reading, and goes on throughout the rest of the regulation to lay out various provisions for what will constitute proof of readings of meters. So, key issues in this appeal, I suggest, will be 8.1 at the end, unless the meter is proved to register incorrectly. This court will have to grapple with what that means. 8.2, a reading from a meter may be proved. We'll also have to address. 8.3, what does it mean a meter shall be regarded? The choice of regarded and not proved. And 8.4, under the exception, so the first part of 8.4, except where it is proved to have begun to register. Now, in a nutshell, my lords, what we say, what my clients say, is that the Deputy District Judge was right, and proof beyond what I might call statutory proof may be led by a customer to prove that at an earlier point, a meter was registering incorrectly.
Could you just repeat that expression, and proof?
Statutory proof?
Yes, just
yes,
repeat what you said exactly.
Yeah, absolutely, my lord. My clients say that the Deputy District Judge was right, and proof beyond what I will term statutory proof, proof in terms of the testing mechanism, Regulation 6 of the regulations, statutory proof is my terminology, may be led by a customer to prove that at an earlier point the meter was registering incorrectly. So we say, as a headline, 8.1, 8.2, and 8.4, the word proved must have the same meaning, or capable of carrying the same meaning.
Sorry, can I just retreat for a second?
Yes.
This is all in the context of the ability of a water undertaker to charge for water supplied by volume. The actual question about whether a consumer owes the water undertaker something depends upon the volume, whether the volume has been supplied. I mean, that's the
consumed knowledge, yes.
Yes, in other words,
yes. That's right, and that is represented, my lord, by the reading of meters.
Right. Well,
yep.
Can I just put out straight away an issue that I have with this, which is that if you look at the opening words to 8, where the undertakers fix charges in relation to any premises by reference to volume,
yes.
A reading from the meter installed in the premises proved in accordance with regulation shall be evidence of the volume of water, which is what gives rise to the ability to charge. And I think you do at some point during your argument also focus on that part, because you say that, for example, in Scotland, the equivalent wording is proved in accordance with this regulation shall be sufficient evidence.
I think it was prima facie to begin with, and then it became sufficient.
I mean, I want to just raise, so you can think about it, and also so Mr. Kitchener can think about it as well. I mean, there is a very well-established legislative technique which would involve just simply saying that a reading from a meter installed in relation to these premises proved in accordance with regulation shall be conclusive evidence of the volume. Since it's the volume that gives rise to the ability to charge. But that isn't what Parliament did. And I think that's, when you've been going through saying we're going to need to grapple with various bits,
yes.
you didn't suggest we will have to grapple with that argument, whether it's sufficient in Scotland, if that's what conclusive means, or conclusive in England. Is that part of your argument?
No, I think, no, our argument is that first proof, we accept that will be proved by that mechanism. What we say, it's the unless provision that comes later. What is the content of that word proved? And that must be informed, we say, by the word proved in the exception in Regulation 8.4. So just to take a step back, Lord, we would accept a reading from a meter installed in relation to these premises proved in accordance with regulation shall be evidence of volume. We would accept that would be evidence of volume.
But it would be evidence.
Yes.
But I thought your argument was that it's not the only evidence that could be adduced as to the volume, which is what gives rise to the entitlement.
That is correct. So there is an argument, I'm just coming to it, of exclusivity, that this is the only method by which that volume can be determined. and therefore proved. What we say is that's not what Parliament is saying. Parliament is saying it may be proved that way, or it may be proved if one looks at 8.2 by producing a certificate, or it may be proved when one looks at the exception in 8.4 by what I might term non-statutory proof.
Of those different things, what you're really trying to say is the meter must have been wrong. There are two things. There's the volume of water and there's the reading from the meter. You accept that in normal circumstances, reading from the meter will determine the amount that the customer has been supplied with and will be charged for. You're not suggesting that it's anything other than the problem with the meter. You're not suggesting there's other evidence to do with the meter or the reading from the meter. You're saying that the reading from the meter is incorrect.
That will be the gateway by looking at the reading of the meter, whether it is correct or incorrect at that point in time. So if it is incorrect, if it is registered incorrectly at that point of testing, what I call present testing, Regulation 8.4 kicks in. So Regulation 4 kicks in, which is a deeming provision, which will say it will be deemed to have been registering incorrectly, two back, basically.
You get 2 quarters back, yeah.
Two readings, I think.
Or 2 readings back,
Yeah.
unless you can show that in fact it was testing properly within one of those 2 periods.
Exactly, my lord, exactly. However, just while I'm examining that, there is a provision in favour of the undertaker that if he doesn't like the 2 back, he has an opportunity in the exception provision under 8.4 to prove it began at a later date than the deemed date, which is 2 back.
Yes.
Now, what we say, the proof there within 8.4 exception cannot be present testing proof by logic. Present testing proof could not demonstrate historic inaccuracy or incorrect registration.
But that's why you need a deeming provision.
Yes.
I mean, you need a deeming provision because the only time that the customer will presumably twig that there's something wrong with what they've been charged is when they get the bill. And if that was the occasion on which you tested the meter and it proved to be faulty when tested, the water company could just simply say, yeah, well, we know it's faulty now, but it wasn't faulty then. So you have to have a deeming provision because otherwise the water companies could always just say, you know, testing now doesn't prove we didn't supply you with the metered volume of water then. So that's what the deeming provision
Yes,
is doing.
we agree with that.
And the proving otherwise, say for example, at reading 1, because you've been in hot dispute for ages, you'd actually had testing at reading 1, then you wouldn't backdate for 2 readings because you know the first reading is correct because you know it's been tested for the first reading or the second reading.
That's right, my lord. And the exception provision in 8.4 would kick in.
But you tested it at the time of the 3rd reading and it's testing incorrectly. You would apply it to the 1st and 2nd readings unless it was testing properly. How do you know it was testing properly? Well, if in fact it had been tested on either reading 1 or reading 2, then you'll be able to work out that the testing problems began at a later date than the beginning of the 2 backdated readings. I think that's what it's getting at.
Where the problem, my lord, lies is if the meter self-corrects itself.
Sorry?
If the meter self-corrects or sorts itself out. So if the meter is registering incorrectly at an earlier point, and let's say it's gunged up with lime scale, and water is turned back on, it abrades, it cleans out, but let's say 2 of the dials turn at the same time, the meter is back registering correctly in terms of the scheme, but the bill has spiked by virtue of the incorrect registration at the earlier point.
But the question in the case is, let's take that scenario that, in other words, it's an intermittent fault, as I would describe it. You know, as you say, a fault that corrects itself. As I understand it, the difference between the parties is that in that scenario, the meter would test, would pass the test at a later stage. And the question, as I understand the issue between the parties, is whether that is determinative of the entitlement of the water supply and undertaker to charge for the previous period, water companies say, yes, it is, as I understand it.
That's right.
Yep.
That's right.
Whereas you say,
We are entitled to prove.
no, it's not conclusive
Indeed.
as to the volume of water which was supplied during the previous period, that being the thing which gives rise to the entitlement to charge.
That's right. And therefore, burden of proof is
Hence my question about whether, in truth, what this case is in reality about is whether, in a sense, the word conclusive is in the earlier part of 8.1.
That's right. Whether it's,
By
I've called it exclusivity, but conclusive would also.
Yeah, and you say it isn't, and it shouldn't be read in, and the water company says, well, it should be because the statutory scheme is intended to be the whole, and nothing else comes into it, as I understand it.
And what we say further,
That's by reference to Regulation 6.
which is a testing regulation, yes, we're on the same page with that. But where we do the difficulty is the situation where the meter has had an intermittent fault, I use that terminology, and fixes itself on the learner-friend construction of these regulations. There'd be no rights, no remedy for a consumer or a spike in volumetric consumption on a reading.
Well, it would be no remedy for consumer, not because of volumetric consumption. It would be no remedy for a customer because the water meter had been faulty.
Yep.
The point
And
is,
if the result of the intermittent fault is that the meter resets itself to 1, then the undertaker would have no remedy either. It cuts both ways. All right. Now, can we, as it were, let you develop your argument in the way you'd like to present it?
Please not. Let me start with what was argued in the lower court in front of Deputy. I will come to the point about the bundle just in a minute, but can I start by looking at what was argued actually in terms of this very point we're discussing before the Deputy District Judge Ginesi, what the original position of Castlewater actually was. And that's important for how she treated this supplementary bundle, please. It's a transcript of the trial. It starts at supplementary bundle 209. I would like to turn to 310.
sorry, I couldn't hear the number, I'm sorry.
310, my lord.
We're in the supplementary bundle at page.
310.
Is that? This is almost a record. I've got within view at the bottom of the page 4 different page numbers. 3 on the page and 1 in my electronic numbering. Which are you going to use?
I'm going to use the red one, my lord, which is 310.
Printed 310.
Printed 310, yes.
It's 101 of the internal transcript numbering, which is 4 pages earlier on the electronic version.
Right, yeah. I think it'd be easier for everybody to refer to the red 301 number, which is, I think, in the bottom right-hand side.
Yes, but that's a different red number on the electronic bundle.
So just to clarify, how many pages are you ahead?
4.
4. So so we can just adjust by 4. That's fine.
Right, we're on page 101 in the middle of the transcript itself.
At the bottom on line 23.
Yes, Mr. O'Sullivan.
Mr. O'Sullivan.
Thank you, I've got that.
Just to be clear, Mr. O'Sullivan is counsel for Castlewater at that point in time. And this is a submission, yes, but where it is proven to exceed those limits of error, it is deemed to be registering incorrectly. I say that what Regulation 8.1 does is give rise to a rule of evidence. It states quite clearly that it shall be evidence of volumetric supply. That does not mean that additional evidence cannot be adduced to show that it was registering incorrectly in some other way, but the court has to be satisfied that the weight of evidence that is advanced to show that it is registering incorrectly has to be sufficiently high to displace the evidential presumption created by Regulation 8.1. So before the Deputy District Judge, the position of Castle Water was that additional evidence. There was not exclusivity in terms of evidence of proof, but other evidence could be led. Now, at the appeal, that position changed, and the exclusivity argument was run, which His Honour Judge Simpkiss accepted, and if we can go to core bundle 35.
Page.
Sorry, I'm sorry, I got that wrong. Core bundle 118.
Thank you.
It starts at paragraph 35, his consideration of the Deputy District Judge's judgment, and I would like to take the court, please, to paragraph 42. That's on page 1.
Well, by paragraph 34, Mr. O'Sullivan had arrived at the point that the respondents now rest upon.
Sorry, my lord.
Paragraph 34. I mean, I was just trying to link what had happened at the two trials.
Yes,
Right. Okay.
absolutely, Lord. Absolutely.
The judge goes on paragraph 35.
And I would like to now go to paragraph 42 to see what the judge said about the exclusivity argument. That's on page 119. Therefore, it is not open to the court to consider other evidence that the readings were incorrect, let alone evidence that the meters were defective, which is not the wording used in the regulation. Any interpretation other than the above would lead to a great deal of uncertainty in metered water bills where a party produced evidence that perhaps the premises had been unoccupied. And that is a position that Castle Water adopt now in this appeal, that is the correct way to approach this, and it is an exclusivity proof component within 8.1.
Sorry, can I just? Sorry, I'm just. This is the Judge Simpkiss,
It is not.
and he recites at 33 the argument by Mr. Keeling-Roberts.
That was counsel for B&B.
Yeah, your predecessor.
My predecessor, yes.
And Mr. Keeling-Roberts is making the point about the argument that it's not conclusive evidence as to the volume of water used, which is the point I've been just trying to identify.
Yes.
Okay.
Yes.
And the judge rejects that contention at 35.
Yes.
Right. So that's the judge's decision on the point. So what are we looking for 42 for?
I was just taking the court to 42 as an expression of the judge's opinion that no other evidence.
Okay, well, he's got there. Okay, so right, you need to read those paragraphs together. Right. Okay. All right. Yep.
Right, up to 43. 35 to 43 is the judge's reasoning on this point.
And I'll finish with 43, my lord. The remedy that a consumer has if there's a doubt about the accuracy of the meter is to ask for a test under Regulation 6.1, in which case that test would be carried out, as indeed it was by Mr. Hurst, and therefore I conclude that this Deputy District Judge's interpretation was wrong, and the interpretation is as I have said. So, that's all I want to say. That was intended as a head note of Ground 1. Ground 2, I can be very short, flows from the first. If we say the Deputy District Judge was right that there can be non-statutory proof, was she right in her treatment of the evidence of the single joint expert, Mr. Hurst? I'd like to say something briefly about Ground 3 as well. We have been given permission to appeal on Ground 3. It's a case advanced in the alternative. The issue is whether in all the circumstances Judge Simpkiss ought to have remitted the case back to the Deputy District Judge. It's not disputed between us that he had the power to do so. The question is whether there was a sufficient factual basis. Now, it's set against us that my predecessor counsel at an earlier hearing conceded or waived any right to challenge quantum, and the judge does indeed record that no challenge to the correctness of the invoices was made, and therefore he said that our clients were debarred. And could I take the court to that? Core bundle at 10910.
By correctness of invoice, you mean the correspondence between the meter readings and the invoice, or the calculations?
That's it, my lord. So you remember that it was to be done on the papers.
Yeah.
If it couldn't be agreed, it wasn't agreed, and he did it on the papers.
And you were going to where? Thank you.
Yeah, sorry, at page 109, my lord.
Thank you.
I just want to show the court what he said about this point. It's at the bottom, at paragraph 13. In his written submissions, Mr. Bigos now seeks to take up the other points that had been abandoned at trial. It was made quite clear by the defendant's counsel that the only issue that needed to be decided was whether the meters were defective. As a result, the Deputy District Judge was not asked to decide the points, which Mr. Bigos now wishes to argue. Had it been an issue, then the Deputy District Judge would have been able to decide them and make findings, even if this decision wouldn't have affected her final decision. Apart from the defective meter point, all the other defences were abandoned at trial. So we accept that situation, and the question is, are our hands tied in this court? And it forbears me to point out very briefly issues with this decision that the judge has come to. The Deputy District Judge made a finding that consumption was never established and it was unsubstantiated. There was no factual basis for the invoiced consumption. The charges for meter 2 were not examined, and there was no reconciliation of payment to account that B&D had made. That didn't appear in this decision. Finally, and perhaps most importantly, when we look at the regulations again, there is a statutory provision for e-balancing or e-reconciliation.
At the moment, do you want to just tell us, you're pursuing ground 3, are you? I mean, I think at the moment, all we need to know is you've got permission, and whatever we make of it, the first thing we need to know is whether it's there or whether this is an elegant way of abandoning it. I'm not quite sure which it is.
Yes, we do have permission. We do accept that we're barred. We do point to the equity of the situation, but we are in the court's hands as to what the proper disposal would be, because issues of proportionality and the overriding objective, I think, would arise in terms of sending this back, plus practicality. How would it that the Deputy District Judge Ginesi would deal with that?
Right, so I'm going to make a note that you accept your barred, but you're in the court's hands in relation to the equity of the situation. Now, that will, I think, suffice for the present time, and we'll devote a proportionate amount of time to that particular ground. Clearly, although ground 2 is of great importance to your clients, ground 1 is the substantial ground for which has engaged the appeal. We're also very much aware, if I may say so, of the disproportionate costs which this dispute has already caused both parties. So we'll hold those matters in mind. But anything else on ground 3 for the moment?
Nothing, my lord.
No, thank you. Okay, so we're back to ground 1.
Could I just check where we are with the bundles? My learner friend does have a problem with the bundles, which I want to come to.
Well, shall we hear from him about that?
Absolutely, my lord.
Thank you. Yes, what's the problem?
Well, the only issue is, and I hadn't realised this until either yesterday or the point on TUI, which I'm sure you picked up from my learned friend's skeleton, that actually only arose in the replacement skeleton. So that arises in a new paragraph
Yes.
that appeared in an unheralded manner
Yes.
in the replacement skeleton. It's not part of the grounds for appeal, and it wasn't.
But I'm accepting that, no doubt, as accurate. Why do we have a dispute about bundles? Is it to do,
it's not really a
with the
dispute about
appearance of an authority in the bundle?
Yeah, it's not really a dispute about the bundles. It's just at that point, and I'm sure my lord is familiar with the guidance of this court, which is that the only purpose of replacement skeletons is to update the bundle reference.
Right. Well, so when we come to the point, because what we're going to be doing is listening.
No, of course.
First, I know you're not seeking to prevent that, but we'll listen first. We will then anticipate that you're going to be making a submission about creeping grounds of appeal and matters of that sort.
And my lord, the most important point is simply this, that you may have looked at my skeleton and wondered why we haven't dealt with TUI, and it's because it wasn't in the original skeleton.
Well, we'll decide what to do with that when we get there.
And I haven't had a chance to address you in writing. Obviously, I'm in a position to do it orally, time permitting.
Well, it's not...
You haven't had a written...
Yeah, this is not abstruse law. It's a fairly general point which we're all very familiar with, and so shall we deal with it when it arises, and we'll bear in mind anything you say then.
I couldn't agree more.
Good, thank you. Right.
So perhaps I could suggest the following structure for my submissions by starting firstly looking at the principles applying to statutory interpretation. Secondly, I want to look at the relevant sections of the regulations in light of those principles. Thirdly, I will address why ground one should succeed on a proper interpretation of those regulations. Now, we may pause at that point in the hands of the court, but if the court wishes me to, I'll go on and address ground two, applying that to the facts of this case and the decisions in the two lower courts. And number 6, address why the respondents are precluded now if 2E comes in.
Say that again.
If 2E is in the bundle, why the respondents would be precluded from now arguing that the single joint expert's evidence should be controverted.
Well, I mean, it's not a question of whether 2E is in the bundle or not. 2E is 2E.
2E is
and as Mr. Kitchener has said, he can deal with it orally. I mean,
2E is a Supreme Court authority. In respect of this, which has a material bearing on this case, particularly in the case of Volpe. The Volpe grounds of appeal decision has to be read in light of the Supreme Court's decision in 2E.
Right.
So we'll come to that when we...
Right, so you're going to make the point that they're precluded from arguing against an uncalled single joint expert.
Yes.
Right, okay. Good. Well, that's a helpful structure. And what is your
my starting point?
Well, I know where your starting point is. It's getting on for 11:10. What I'm equally interested in is your landing point. How much time have you set aside for these matters?
I'm going to endeavour to deal with the ground one point within an hour, if I can. It would assist me if the court could give me some indication of how familiar the court is with the interpretive provisions of the case.
I think if you set it out, and insofar as we're finding that we're very familiar with it, because I'm sure it's covering a lot of ground, but sometimes it's interesting to see how it operates in a particular section. So we don't want to predict that, but start off on that. But assuming you're not unduly hampered by interventions, what is your intended time of arrival?
So I am hoping to be finished before lunchtime with both sections, ground one and ground two.
Well, you'll certainly need to deal with ground two, whatever happens with ground one, because we won't have made our mind up about that during the course as we sit here. And
I
if
don't
you're
intend to say anything else about ground three.
all right, well, let's see whether you're likely to be finished by 2:15 or 1 o'clock. We'll see how we go, but certainly before the lunch adjournment.
Well, with that helpful guidance, my lord,
thank you.
I will take the court to the authorities, and I will highlight sections of the authorities that I say are important important in this case,
Yep.
but I will take it as read that the court is familiar with the authority. And my departure point, my step-up point is, of course, the Crown on behalf of O and Secretary of State for Home Department.
Yes, that's tab 16, is it?
Tab 16
Thank you.
at 7, 9.
Right. Good. And your references in that are?
Just before I start, what I maybe ought to have said is, if you've got sidetracked with the bundles issue, there's an additional bundle from us
Yes.
with two recent, this year, Supreme Court cases referencing this case, which we thought we were duty-bound to place in front of the court.
Thank you.
So, I can take the court to
Right,
that
we've got that.
as necessary. That's a case of Wathen Fiat and the Scottish Appeal
Yes.
of Forwood in Scotland.
Good.
But if we could go to 195, please. This is Lord Hodge laying out what he says at 28. It's opportune to say something about the process of statutory interpretation. The courts in conducting statutory
You
interpretation.
don't need to.
Well,
you
that's
can
good.
save this, but which? I mean, which paragraphs would you like us to?
29
read? Yes.
and 30,
Yes.
31.
Yes. Thank you.
And
Well,
just in passing, could I just bring the court's attention to a section in that paragraph 29, which was omitted from the decision of His Honour Judge Simpkiss.
right.
which
Well,
is
we'll
quite
remind
important.
ourselves of 29 to 31, and then you can focus in.
Yes.
Just give us a moment.
Punitive, yeah. Booby trap.
Yes, thank you.
The passage I would like to bring to the court's attention, which was omitted by Judge Simpkiss, and which we say is important here, can be found on that page 195, between the letters C and D, commencing with, "There is an important constitutional."
Right, so the last bit of paragraph 29.
That's right, no.
Yes. Okay.
That is an important consideration, we say, for legal certainty, and which was not repeated by Judge Simpkiss in his decision. Now, just while we're looking at this section of the report, could I just bring to the court's attention at page 196, at paragraph 32, in connection with the Pepper and Hart rule and reference to Hansard and parliamentary material. I don't need to go into it at the moment, but I might anticipate we will return to it depending on what my learned friends decide to do with material that they have lodged. So I just flagged that just now, and if I could now...
I'm not going to be dealing with Hansard.
You're not referring to...
Yes.
Let's move on to Lady Arden,
Yes.
who also had something to say about this. Page 204.
Page.
204.
Sorry, it helps if you speak up a bit.
I'm sorry.
Thank you very much. Lady Arden, yes.
Yes.
Paragraph
58, 59, and 60.
yes.
And for the record, paragraph 60 was not referred by His Honour Judge Simpkiss. Again, paragraph 60, which is again a reference to the legal certainty issue. Now, my lords, what I take from that case is the following. The words in the regulations, such as the 1988 regulations, are used in a particular context and derive their meaning from that context. Secondly, any interpretation has to strive for legislative coherence, which means that the same words have the same meaning throughout regulations, and the converse, different words, must be presumed to have different meanings unless they are part of that statutory interpretation and are deemed synonymous. Thirdly, finding parliamentary intention is an objective process, and there is a presumption against absurdity. And fourthly, customers and consumers in regulations such as these should be able to understand what is said, and the court should give effect to legal certainty. Now, in terms of the second point, with the same words having the same meaning, as I say, there have been two recent Supreme Court authorities addressing that point. I don't intend to turn them up, but if I could perhaps give the reference to the court.
Yes.
The first one is For Women Scotland in the supplementary bundle, which is at page 29 of the bundle, and I would draw the court's attention to paragraphs 12 to 14.
Right. Well, we'll look at those
Oh, indeed.
now just to see what.
Yes, indeed. Absolutely. So just for context, this is...
Well, let us just
I'm
read
sorry.
what they say, 12 to 14. Well, one might expect it, but these are all saying the same thing, aren't they?
emphasizing the same word having the same meaning. I would say just adding to O articulates it further, if I may put it that way. The same point is made, my lord, in the case of Watton Fayed,
Yes.
which is page 12 of the same bundle,
Yes.
where the
Paragraph.
court discusses general principles and particular principles in relation to the same word, same meaning.
And the paragraph you want.
It is... It starts at 53, general principles, 54, and then 55 deals with particular principles. And at 56, there's a discussion of the presumption that a word has the same meaning throughout the Act when used more than once in the same statute. So a repetition again, but a reinforcement by the Supreme Court of the point I'm making.
Yes. Thank you.
Now, I intend to turn to the regulations themselves and apply what we just read to the wording within that regulation, as we must.
Right.
And
So we're now in section 2 of your address.
Exactly right.
Thank you.
And the water meters regulations 1988 can be found in the authorities bundle at 12. it's not in dispute. They were made under the Public Utility Transfers and Water Charges Act 1988. Now, in light of what we've just read with Lady Arden in O, one can start with the explanatory notes, which...
Can I just pause? Are you at some point going to take us to the underlying legislation or the underlying statutory basis for charging?
I can do, my lord. I can. I wasn't proposing to, but I will.
Well, given that we're going to be looking at these regulations, which are all to do with charging, I mean, there must be there is, I know, a statute which sets out the basis upon which you can charge, and also the basis on which these regulations have been authorised.
Yes. So I don't understand those to be put in the bundle by either party.
Well, they
my
the bundle
supplemental.
arrived this morning.
It's in my supplemental authorities.
Yes, thank you.
From page 2 in particular. You need to just have reference to section 5.
2 and 5, I think. 2
and 5. 5.
Have you got access to that?
Yes.
There we go. All right. Well, so we're looking at the beginning of the respondent supplemental bundle. At some point, somebody can tell us, please, when you could first charge for water in England,
When?
just to give us a bit of history, but not now.
Or well.
We too need water.
Well,
I can try and.
We will come back to that.
Well, I mean, it would be terrible if we were.
But do you mean by volume, or because obviously traditionally it was done by rate?
No, I just want a little bit of history as to, because presumably there came a time when there was a water rate, and before that there was a time when there wasn't a water rate.
Yes, I think my lord is actually making the point that presumably at some point you didn't have to pay for water at all, and then you had a rate by reference to the value of the property.
It was done by rateable value, exactly.
And then there was at some point an ability to charge by metered volume, or by volume anyway.
So I'm sure it's not going to make. I know it's not going to make the least bit of difference to the outcome of this appeal, but it's useful when we're looking at a branch of the matter which is represented by a regulation that we should be able to understand what the trunk consists of, and this is an important part of it. But let's let Mr. Parrott get on with it for the moment. And
that's homework, my lord. We'll come back with that. When did it first start, and what is the enabling to allow the charging of water, as I understand the request. Thank you. So, yes, we're looking at the explanatory notes of the regulations.
No, we were actually at the moment, but before I interrupted you, we were looking at the underlying enabling act, which is said, I think, to give us the answer to the question of how these regulations came to be made and how people get charged for their water nowadays.
Let me take a step back. I did say that. I said it's no dispute between the parties that the Public Utility Transfers and Water Charges Act 1998, it is under those regulations, that act, that the regulations are made. That is not in dispute. And I'm told Section 2 of the Act makes provision for charges.
Right, so Section 2 provides authority to the power to fix charges and demand and recover charges.
Yes, and then regulation part 5 is.
Well, it's useful to look at section 5.
5.
Oh, you said regulation 5, because
Exactly.
that says what the regulations can be made for. It's not the answer, because they might be made for a range of purposes, and it might only be one purpose, but it is helpful in terms of understanding the structure of the regulations to see what Parliament authorised the Secretary of State to do.
Yes, that's right, my lord. So 5 is, I think it's regulation 5, is that right? Provisions relating to meters.
Section 5.
Section, thank you, section 5, dealing with meters, and the point is made that it's helpful in terms of statutory thinking, parliamentary thinking. Now,
So under section 5, subsection 3, the regulations may regulate the positioning of a water meter. That's A. C, provide for a reading from a meter to be proved in such manner as may be specified in the regulations, and for a reading from a meter to be such evidence as may be so specified of the volume of water supplied to any premises.
Mhm.
So that's the enabling provision.
It is not.
And then D, fix a method of determining the amount of the charges to be paid where it appears that a meter has given or may have given an incorrect reading. So there are two things here as I understand it.
Mhm.
The first is that if you're going to now, it's implicit, if you're going to charge by volume, then the evidence, a meter can be such evidence as may be specified of the volume supplied. That's what it appears to be. But yet the regulations have to specify what evidence the meter reading may be of the volume of water supplied. Yeah.
That's right. Such evidence as may be so specified. So what we would say is there's no language within that provision for absolute or exclusive methods of that proof, or indeed evidence.
Because the actual charges that you can levy are actually under Section 2.
Yes.
There has to be a scheme, a charging scheme, I think. Under, is it a statutory water company may fix any of its charges by means of a scheme under Section 31?
Yep.
Charges, schemes.
That's Section 2.2, subsection 2.
Yeah, and that's where you'll actually find, presumably, the ability to charge by volume. Is that right?
Hopefully find the answer. Answer there. I'm obliged.
All right. Well, we may come back to those, but that's the underlying statute. And you want to
Look
then
at
come to the regulations themselves.
So I propose to systematically go through H1 to 4, just drawing the court's attention to some of the words that are used. But the starting point per Lady Ardent is to look at the explanatory notes of such provision. That can be found at Authority Bundle 17.
Yes.
The relevant part is part 3. Provides for meters to be tested and for a reading from the meter to be evidence of the volume of water supplied. That is,
Sorry, I've actually missed where you are.
That's page 17.
I'm sorry, my lord.
Back in,
A17.
Bottom of page 17.
back in the explanatory note.
Yes.
Okay.
Yeah. A17 is the explanatory note, my lord,
Yeah,
to
yeah,
the
yeah, yeah.
regulations.
Yeah.
I'm referring to part 3.
Yeah.
And we would say that's neutral language, perhaps reflecting the Enabling Act that we've just looked at. So where we go next is Regulation 8 itself in the heading that appears there, method of proof and effects of meter reading. This is the regulation that deals with proof. There's no other regulation within these regulations which addresses the question of proof. And
We have to look, don't we? I mean, as we're doing this for the first time, methodically, we have to look, don't we, the whole of Part 3. Indeed, the whole of the legislation, but the regulations that seem to have any bearing on this are 6, 8 and 9, aren't they?
That's quite a lot.
Yeah.
I think
In one sense, don't you really need to start with part 2? The point is you start with meters should be so installed as to ensure that they are reasonably accessible for reading, inspection, testing and maintenance. So you're going to have meters installed in a place where they can be inspected and tested and read.
I missed the reference note. Is that regulation
3.1.
3.1?
Part 2, regulation 3.1.
Yes.
Well, it's not surprising there's a lot of reference to water meters because they are the water meters regulations. But that in a sense, all parts of the regulations are potentially capable of assisting us in understanding what they mean.
Yes.
But I perfectly understand that you
The
focus particularly on regulation 8.
which is proof. And therefore we say that it's this regulation that circumscribes, deals only with proof. There is no other part of the regulations dealing with proof. There is a tie back to regulation 6, which is a testing regime under 6162, but it's within the four corners of this regulation. We should find the answer to what is meant by proof. As we will come to, there is reference to proved, may be proved, regarded as, and found. We'll see that as we go through. And the question will be, are they different or are they the same? Are they synonymous? Do they carry the same meaning or not? We suggest not. So just reading H1, where undertakers fix charges in relation to premises by reference to volume, our reading from a meter installed in relation to those premises proved in accordance with this regulation. Pausing there, that must be, it is a reading that is proved in accordance with this small r regulation. Now, that must be a reference to only this regulation, we would say, because to give an example, if we look at 5, regulation 5, it does reference sometimes other regulations in the regulations under reference to a capitalization and a number. So regulation 5.1 subject to regulations 3 and 4. That is not done here. It is in accordance with this regulation, which we say lay weight to my argument that our argument that it is the four corners of this regulation that deal with proof. Shall be evidence is indeed imperative, and read naturally means that a meter reading, if proved in accordance with regulation, is conclusive proof in the absence of contrary proof. The point we looked at earlier, we accept that, but critically, Parliament immediately qualifies this with the express exception.
Sorry, could you just? Sorry, it's me. I'm sorry. You were reading down, and I couldn't detect. Sorry, I just didn't hear what you said accurately.
It's my fault.
Can you go over it again?
I'll raise the volume clearly. Let me take a step back. I was looking at shall be in H1.
Yep.
And I am saying it is imperative and read naturally. It means that a meter reading, if proved in accordance with Regulation 8, is conclusive in the absence of contrary proof.
So you do accept?
That is accepted by us. That's the point I was trying to make.
So you accept that we should read in the word conclusive into
in that proof, in the first proof, but not the second proof, as I will come to. Because that is what Parliament, that is what the statute makes provision for, which shall be.
Wait a second.
So your reading is, if you can charge under the scheme by volume, and you can, we assume, under this scheme, and if you've got a reading proved by the certificate of regulation 8.2, that is the amount you must pay, except unless the meter is proved to register correctly.
That's where I'm going.
Right. So
it is the unless provision and the use of the word proof in the unless. I'm sorry.
okay. I'm sorry. I'm not following, because unless I've misunderstood what you've just said to us, you are adopting the diametrically opposed position to your predecessor in front of the district judge. In other words, as I understand it, you showed us the transcript, and I thought your predecessor argued.
That was my predecessor. The purpose of the transcript was to show the position that had been taken by Castle Water.
Yes. Sorry, yes, sorry, I'm so sorry.
Yes.
Yeah, that's right. The Castle Water was saying it's
Additional. They said. Additional.
Castle Water was saying no. Sorry, wait a minute. Okay. Anyway, right. You say you accept that it's conclusive evidence absent unless
it is evidence.
No,
shall be evidence.
Yeah, but you say we read it as conclusive evidence.
Subject to
we
the
have to be
meter.
careful about the word evidence and proof, because we are drawing from the other uses of the word prove a particular meaning as applied throughout this regulation. So if we can park maybe evidence per se and look at only proof, what we are saying is under 8.4, it permits of non-statutory proof, and therefore where it appears above in the unless provision, must also include non-statutory proof.
Okay.
So the key...
It would be helpful perhaps if you could just situate the submission you're making within the skeleton argument that we have from you, because obviously after the hearing we will refer to both in order to see where we are.
Yeah, I'll locate that.
But because I think we need to understand whether your appeal fundamentally depends upon 8.1 or 8.3, and what the focus of your challenge is. So could we start with your skeleton argument and see what it was that was being said there? I think I'm picking it up at 26, paragraph 26, which is at our page
32.
Yeah, and we develop it at 29, 30, 31, and 32. So we reference unless meters prove to register incorrectly. What?
I confused the matters earlier when I referred to the transcript or whatever. Sorry, what I had in mind, just so I'm clear, is what you showed us from the circuit judge's judgment at page 118 of the call, where Mr. Keeling Roberts, who I think was your predecessor.
Yes.
Sorry, I misread you. I'm very sorry. That paragraph said that your predecessor, Mr. Keeling Roberts, said his actual argument was that the regulation was not couched in prescriptive terms. It does not say that a meter registering correctly on test is conclusive evidence of the volume of water used. So that was the argument your predecessor was putting.
Yes.
In other words, drawing attention to the fact that the word conclusive was not used, as I understand it, in Regulation 8, and was saying the regulation is not couched in what he said was prescriptive terms. But when I heard you a few minutes ago, you said, I thought the exact converse.
No.
Have I misunderstood? And I'm
It's
sorry
my
if I
fault.
have.
It's my fault. I'm not saying that. I'm not saying that. What I'm saying is that it is a source of evidence, but it is not the only source of evidence.
Yeah,
So
it was
it
your
is-
use of the word imperative, I think you used, and I couldn't really focus on what you meant by
That
it.
alters mine.
And then,
No, I adhere to that position. So our position is, it is a source of evidence, but it is not the only source of evidence, and it is not a conclusive in the sense of only being available source of evidence.
Right. Okay.
I hope I've clarified that.
Right. So back to where we were.
And just to finish, that's in our skeleton. It's 20 minutes onwards. Now, I want to come to the unless provision within H1.
Yes.
So it states, unless, so let me read it in context. A reading from the meter installed in relation to these premises proved in accordance with this regulation shall be evidence of the volume of water supplied to those premises unless the meter is proved to register incorrectly.
Right.
Now, parties diverge here. We say the proof there can be non-statutory proof. It can be beyond, my learned friends would point to 8.3. They want to read 8.3 on the back of 8.1. We say, on a proper construction of the word proved, it must carry more than statutory proof, but also non-statutory proof. And what we therefore have, looking at the 4 regulations, is 3 kinds of proof. We have the statutory proof that we've just discussed. We have 8.2 certification proof, certificate proof. And finally, we have, under reference to a construction of 8.4 exception, non-statutory proof.
Go back before you develop this to 8.1 again. It would appear to go like this. That a reading from the meter shall be evidence of the volume of water supplied, unless the meter is proved to register incorrectly. So if the meter is proved to register incorrectly, then the reading of the meter is not evidence of the water supply.
Not proved, yes.
Right, so that fits with your reading of this. It may be,
Yes.
but it isn't to do with the volume of water supplied, the proviso here, the unless. It's to do with the evidential value of the meter reading.
Yes, whether it's registered incorrectly or not.
So the consequence, I'm not saying that this is correct, I'm just saying this is how I'm reading it.
Yes.
The consequence of the meter being proved to register incorrectly is that its reading does not have the evidential value that that subsection otherwise grants it.
Exactly. It cannot have the evidence of volume.
Yes. Well, it's to do with the reading from the meter. If we're being, as we have to be, very exact in looking at this in the first place, that the reading from the meter is effectively knocked out. That may then relate to the volume of water, but the reading from the meter is what is being provisoed by this.
yeah, so as I understand it, you can only charge for volume of water. You charge by reference to volume. If we got the contract, got the underlying scheme, I suspect we'll find that the water supplier charges so much per cubic, whatever it is, of water supplied. That's the scheme. You're entitled to charge by volume. If you have a meter reading, it is evidence of the volume of water supplied, which entitles you to charge, unless the meter is proved to register incorrectly. So that if, as my lord said, the meter is proved to register correctly, that meter reading is knocked out as the means of proving the volume of water supplied.
I'd agree.
I ask you a question, please, about your use of 8.1 and 8.2 and a different type of proof being a certificate proof. Another way of reading this is if you look at 8.1, it says where you charge by reference to volume, a reading from the meter proved in accordance with this regulation is evidence of the water supplied, unless the meter is proved to register incorrectly. 2 is giving substance to 8.1. It tells you a reading from the meter is to be proved. You've got to have a certificate from a duly authorised person. So one wonders then whether 8.3 isn't doing the same thing for the other bit of 8.1. It tells you how the meter is to be proved to register incorrectly, and it shall be proved to register incorrectly if when it's tested it doesn't work. So little 3 interprets one half, little 2 interprets the first half. So 8.1 and 2 and 3 go together.
They're certainly all in the present tense. 8.2, we would agree follows. It's a follow-on, isn't it? Because it does reference our reading.
8.2 is telling you how it's going to be proved, how a reading is to be proved. It's not enough to have a piece of paper saying 50,000 cubic square meters or whatever it is. It's got to be accompanied by a certificate.
Yes.
It's not enough to say it's a reading from a meter, because the meter might be proved to register incorrectly. So how do you know if the meter is registered incorrectly? And in 3 it tells you. You must regard it as registering incorrectly if it's outside the prescribed limits. Is that one way of reading Regulation 8.1 and 2 and 3?
I do. I accept that. That is one construction of that.
But you don't accept that you notionally insert the word only into sub 3?
No, we don't. We don't accept that. That's where the parties diverge.
But on this analysis, you see, you're not inserting the word only. You're saying that 8.1.3 is a statement of when the meter is proved to register incorrectly. You don't need to register the only, because it is, although you don't like the word definition, it is describing the circumstances in which it is to be regarded as registering incorrectly, is what your opponent will say, I'm sure, in a minute.
I see that. What we would say, however, is the unless the meter is proved part still leaves the door open to us to lead other proof of registering incorrectly.
Yeah.
I don't demur from the Lord's flow through, if I can put it that way, 8.1, 8.2, 8.3, with 8.2 and 8.3 complementing and giving body and substance to that. What is slightly problematic is why would it not say in 8.3 a meter shall be regarded or proved as registering correctly? Why is it regarded, I suppose, would be the question.
Because it's describing the circumstances outlined in 8.1. You know that it's got to be, the reading's got to be certified and the meter has to not be proved to register incorrectly. And how do you know when the meter's not proved to register incorrectly? 3 tells you why. So it shall be regarded means, i.e., in these circumstances, it's not registering correctly when it's tested and found to be the prescribed limit. So that would be the answer to your rhetorical question.
Yes. So, and that would be a tie back to Regulation 6 testing.
Well, it would be reinforced by Regulation 6. They required meetings to be available for reading. They require them to be tested. And that's linked in then with 8.3. It's still not the complete answer, but that's what your opponent is going to say in a minute, I imagine.
Indeed.
I mean, we know that in the way that these things are likely to work, you've got supply, bill, dispute. And you only test the meter, generally speaking, you would think, where there's a dispute. I mean, people just don't randomly call up and think it's a good day to have their water meter tested. They do so because there's a dispute. That's what seems to be envisaged. I mean, you can ask your water undertaker to test the accuracy of your meter, but I don't suppose Parliament really intended people would just routinely do that. But
I suppose there's 2 things, my Lord. Reading and testing.
Yeah.
So the undertaker was really duty bound to read the meter. I think the off-what recommendation was twice a year, once a year. And it's in his interest to do so by virtue of 8.4. But as your Lordship's identifying on testing, that is Regulation 6 testing.
But what I'm trying to give. If you give me a moment, I'm going to come on to what the word regarded might mean. 8.1 is dealing with the position in relation to when the water is supplied. You know, you look at the meter reading by reference to the volume.
Yeah.
Okay. Unless the meter is proved to register incorrectly. 3 says that a meter shall be regarded as registering incorrectly for the purposes of 8.1 if on being tested it's found to exceed the prescribed limits of error. But there is a timing disconnect likely to be there between when you test and when the volume was supplied.
Yes.
And the regarded, does that essentially just capture the timing difference that
I see the force in that.
that
Yes.
it is regarded for the purposes of 8.1 as having been registered incorrectly if you subsequently test it and it is outside the prescribed limits. And then 8.4 goes on to say how that actually works out. Now, is that an explanation for the use of the expression regarded and why it isn't perhaps proved? It's because it's dealing with you must regard it as having registered incorrectly for the period of supply under 8.1 if you test it and it's inaccurate. I'm just throwing it out. I'm not saying that's a view that I've formed. I'm just trying to
I see that.
understand.
It's a disconnect, isn't it? The disconnect between the test and what the true position is, and therefore cannot be proof. To answer my own question, it cannot be a proof.
Yeah.
Therefore has to be regarded. I see force in that.
People understand here what would happen. You know, what's going to happen is that people get a big water bill they don't like.
Yeah.
They think something's gone wrong with the meter, so they call up the water supplier and say, "Please, can we test the meter?" The meter's then tested.
Yes.
It's found to register inaccurately, and it's regarded for the purposes of the prior supply, the volume requirement that underlies the charging, as having quotes
Too bad.
registered inaccurately. I mean, that's one way of reading the word regard, giving why they use the word regarded.
I don't think. I think we're
probably done something.
we're feeding back that we're not that smitten by the regarded word. There are other stronger features
Yes.
to the argument, perhaps.
Yes, indeed. Your Lordship referenced inaccurate. Just to note, 8 is about registering incorrectly. 6 references inaccuracy. We can look at that very briefly.
Yes.
6.1. The undertakers or any person duly authorised by them may at any time and shall have so requested in writing by the customer test the accuracy of any meter which has been installed.
I understand the word accuracy is used there. The register is used in 8. But what's the importance of that, other than that they've used 2 different words?
I think that's it. I think we have used 2 different words.
Well, they clearly have.
To your Lordship, to what was said in O about using the same words and using different words, and different words are to carry different meaning. But I agree, in this situation, inaccuracy in registering incorrectly will be.
Well, if it's registering incorrectly, then it must be inaccurate. So they say that it's inaccurate, or they test for the accuracy by seeing whether it registers correctly. That's the point of having a meter.
We don't take a point with respect to that. I merely bring it to the court's attention as references made to accuracy.
Could I? It's just a thought that I have, and I mention it now so that I don't forget later. Could we have just a statement of the costs at each level of this matter? So far, I've read what the figures are, but I think it would be much better for you collectively just to put in an agreed page saying what the costs on both sides are said to have been since this meter was read.
Right.
All right. Thank you.
I'll do that. That takes me to 8.4, which is
Yes.
central proof. central part of our argument and brings me towards the end. Let me start by reading, without an exception, so halfway along H4, a meter which is found to exceed the prescribed limits of error shall be deemed to have done so since the last occasion but one on which the undertakers or any person duly authorised by them last read the meter for the purpose of ascertaining the volume of water supplied to the premises. So if, on the example, there's a complaint and the meter is tested, and at that point, this is an important point, the meter at that point is registering incorrectly, the deeming provisions will kick in. And it is too back, in essence. And this is where the exception comes in. Because it will be open to the undertaker to show that too back is too far. It should be at a later date than that deemed date. Now, what we say is the word proved there in the exception could not be by statutory proof or present testing. That has to be proved by some other source of evidence because it is historical. Because it is
Why couldn't it have been proved by an earlier testing? Say you've got period 1, period 2 in the testing. You've obviously got to deem it back because you haven't, you've got to have something else. But if you've had you tested in period 1 and you had tested in period 2, then it would have been registering accurately in period 1, possibly accurately in period 2, and that's why you don't go back to. It doesn't necessarily tell you that the undertaker is free to... Sorry, Mr. Kitcher is passing out. No, he's survived. It doesn't necessarily show you that the undertaker is to have a broader power of bringing in more things to show that his meter was working if he's got nothing other than the fact he hasn't tested and he's now got a meter that's not testing. Why should you read it in the undertaker's favour to give him more chances?
One could read it in either party's favour. My point is, it's the word proved.
Yes, you're saying that here is a clear example of contemplating non-statutory proof.
Exactly.
Right, to which the answer is perhaps going to be that's in a case of a meter that doesn't pass the test. But I mean, there it is. I mean, and one would have to contemplate matters.
When one comes to it from the point of view of statutory interpretation,
Yes.
applying the canons of construction, that's where we find ourselves. That word proved there must have a meaning beyond statutory proof. And if that is the case, and I can bring this to a conclusion quickly, if that is the case, then it must mean that unless the meter is proved above, could also carry a non-statutory proof.
Right.
That, in essence, is the position.
So you're making the link between proof in 4 and proof at the end of 1.
Sorry, my Lord.
Proof in 4 and proof at the end of 1. The word prove, which appears both in 4 and in 1.
Yes.
Sub paragraph 1. Okay.
Can be given the same meaning.
Thank you.
Yes.
Can I just put we take, as my Lord Justice Lewis said, a couple of successive periods, and then there's a test, and you test the meter, and it's shown at that in the middle of period 3, shall we say, to have been registering. I'm assuming it's been read incidentally at the end of each period. Okay, but in period 3, you prove the meter is registering outside the statutory parameters inaccurately. As I understand it, the basic rule is you then effectively deem it to have been registering inaccurately on the last occasion but 1.
That's right.
So you'd go in fact back to the end of the first period. Right?
Yes.
Except where it's proved to have begun to register inaccurately on some later date. So you say it would be open to the water supplier to say, actually, we can show that that fault was, let's say, attributable to some change in the let's say it's an electronic meter, some change in the software which we introduced at some later stage, or some other thing that happened at a later date, so as to, as it were, legitimise their charges for the earlier period.
Yes.
That's the way I understand that.
Yes, exactly right. And therefore restrict
But
the
that,
liability for the deemed period.
right, and the proof that the undertaker could bring forward would either relate to the reason why the water meter started reading inaccurately.
Absolutely.
Well, it would have to relate to the, wouldn't it, to the reading of the why the water meter read inaccurately. Yes. So
our point is it would be non-statutory proof, though, wouldn't it? It wouldn't be the testing regime proof that is referred to above. It is other proof that.
Well, it would be other testing of the water meter or some other evidence in relation to how the water meter operated. Right.
You'd have evidence other than the fact that it didn't meet the prescribed limits on particular dates, or did meet the prescribed limits on particular dates. What that evidence would be, it might be electronic evidence.
That's the point.
That's your point.
That's the point.
Yeah. It could be that the fault was caused by a particular flushing of the system at an intermediate stage, for example, or something like that.
Exactly. Then we can develop it and think about what happens if the meter is tested and it registers accurately. Is the customer still entitled, in a similar way, to be referring to earlier proof to demonstrate that it was registering inaccurately?
Well, that's the point of the question.
Right, incorrectly.
So you're, as I understand it, saying that it's source for the goose and source for the gander under 1 and 4. That's the point.
That's the point.
Thank you.
That is the point. Now, ground 2 follows from ground 1.
And as I understand it, you say it has to be that way because otherwise an intermittent fault that affected a water meter would effectively be not capable of being
proved,
correctable or proved.
Yeah, it would disappear. So you'd be left with a spike, but without any opportunity to show how the spike had arisen.
Well, you just say, as I understand it, you'd say that if we read the statute, if we read the regulations the way that the water company wishes us to read them, then intermittent faults with a water meter are just not properly provided for.
I think I called it transient, but yes, absolutely. That's right. The intermittent fault would never be dealt with.
And that might fall to the advantage of the supplier or to the customer. You've got to live with the two unless there's testing, if you don't allow other evidence.
Yes. And obviously reading the meters is very important here. In this case, it wasn't read for many years. And so when one thinks about the operation of 8.4 here, the deemed 2 back would have taken us to...
That's their problem. They should be reading it properly.
2016.
Before we leave these regulations, can we look at 9, please?
Yes.
This provides for the taking of an account consequent on an incorrect reading, an incorrect test result.
Both, my lord, isn't it? Both an incorrect, registering incorrectly or deemed to have registered incorrectly.
Yes, so this is how you adjust the charges, and you do so with reference to what is found to be the volume that would have been supplied to the house preceding the last occasion on which the meter was read.
Is your lordship taking me to 2?
9.2.
Yeah, the problem there is the word house. House is defined here as...
I see, so are we outside?
We're outside 2.
Right.
We are in 1. So when earlier I was taking...
Thank you, that's helpful.
I was taking the court to what Judge Simpkiss was...
So there's a provision for domestic users, but 9.1 is for everybody, you say?
That's defined as a dwelling house, yes.
And so the account is to be taken... Right, and that's open-ended.
With 9.1 then, if you're a non-domestic premise, does it mean, if the other side are right, that what you do is make the adjustment? Well, how do you charge for the 2 back reading periods if you're a non-domestic user?
I don't know the answer to that question. It would have to be... Because it's been deemed to go back to, unless it's proven to be at a later date.
Perhaps the problem is theirs, because they rely on the reading as proof. Sorry, cancel that sentence, they don't. They rely on the reading as evidence. And if the reading is incorrect, they can't rely on evidence. So it's for them then to show over the last 2 periods what water they supplied. It's their problem. Is that it?
And how would they show?
That's their problem.
Yeah.
I'm not a water person.
But they could, could they not say, well, we will look at the prior consumption, period by period by period, and it's pretty static. It would be wrong for them to receive no payment for the volume of water which they supplied, but they just can't rely on the water meter. But they could say, well, the court could infer a continuation of the same volume of supply.
That's inference, isn't it? Inference from facts drawn from.
But it's an
my
evidence.
point is, it's still evidence in a different way.
You, the customer, customer might not be. You wouldn't deny you had water. You'd got a business. You continue to conduct it. Everybody knows you've had water. They just can't rely on the water meter because it's registering inaccurately. It's deemed not to have been registered correctly for 2 periods. What happens is that they would have to adduce some evidence or some proposition that the court could accept or review about the volume of water that you had received during the period.
That's
the
right.
account.
Some evidence, whether it's inference from a static supply.
In other words, they wouldn't be unable to prove the volume of water supplied just because the meter didn't work.
And it's open to them to leak that proof.
Yeah.
And that is why we say the word proved.
Source of the goose is source of the gander. You say we can prove by another means that even though the meter passed the statutory test at a later period, at a later date, that actually the number on the meter can't, for whatever reason, reflect the true volume of water he was supplied with.
Yes.
Right. Okay.
Agreed.
So have we done the regulations now?
I'm sorry.
We've done the regulations.
That's the end of
Thank you.
Ground 2, other than my formal invitation to the court to uphold Ground 1, set aside the judgment of His Honour Judge Simpkiss and restore the order of the Deputy District Judge Ginesi. Now, I don't know how I'm doing on time.
We're doing fine. Yes. Okay. So we're now on to Ground 2, are we?
If you wish.
Yes. Thank you.
Okay. Now, my Lord, the question that arises with this ground of appeal, which can be found for the reference core bundle at page 18 forwards, is whether His Honour Judge Simpkiss was right to interfere with the trial judge's core fact-finding functions, particularly in relation to the single joint expert's evidence and the inference drawn from the undisputed consumption spike, and whether he was right to overturn her findings of fact. Here, my clients seek to show that her acceptance of the single joint expert's opinion evidence was legally permissible, properly reasoned, squarely within the scope of a trial judge's evaluative discretion. The essence for us, my Lord, is that she was not led by the nose by the experts. She gathered the information, she analysed it, she accepted or rejected evidence, and that she accepted, she placed weight upon. And therefore, everything she did passed through the crucible of her mind, as opposed to an adoption of what the expert was saying. Now, this ground also addresses, this is a 2E issue, the failure to cross-examine the single joint expert and what that in law means. We say it placed significant procedural and legal limitations on their ability, I should say, to undermine his conclusions. Finally, under this ground of heads as an introduction, this court will be well aware of Volpe and Volpe, what is referred to as the well-trodden path with settled principles. What the task of Judge Simpkiss was, or ought to have been, was to review the judgment in light of the various sections of that guidance. Where 2E takes us let me deal with Volpe first. If I could have Volpe open, please. It's the authorities bundle at 170. And this is
Yes. Right. Well, this is very familiar. Just take us to the paragraph or subparagraph that you particularly rely on.
2, 5, 6.
This is sub 2.
I'm sorry, my lord.
Yes.
Sub 2.
2,
the
little
adverb
1,
plainly,
5, 6.
5, 6, and then number 4 at the bottom, similar caution. And I say that number 4 has to be read in light of the Supreme Court decision. And finally, number 5.
Yes. All right. Well, that, as
I
I
will
said,
come back to that
is
when we put
familiar.
the findings of Judge Ginesi under the spotlight. But as I say, 4 has to be read in light of 2E on appeal to the Supreme Court. Could we turn to that, please? Authorities bundle at page 222. Is where the report starts, and I would like to commence by looking at the dissenting opinion of Lord Justice Bean at 238. At 33. Quoting Fixin on evidence. I don't propose to read it, my lords. Unless your lordship wishes me to do so.
What happened in this case? What had the experts said and what was gainsaid? Because in a sense, one needs to understand that, to understand the principles.
Yes.
Are you able just to summarise quickly the facts?
Yes, yes.
What the evidence was and what hadn't been challenged?
Yes, a family went to Turkey, as I recall, on holiday, and the chap came down with very serious food poisoning.
Yeah.
Sorry,
Yes,
carry on.
please.
Yeah, and it was alleged it was the tour operator, package travel operator, that had caused his gastroenteritis and other nasties, and he had come back to the UK and brought proceedings against TUI, which is a travel.
No, I understand that. So the evidence of the expert was that the cause of the norovirus was the food and drink at the hotel. That's it. Okay.
That's it. So it was Pennington, Professor Pennington,
Yeah.
who was the expert, and part of his evidence, my lord, was not challenged in cross-examination. That's where we got to, and the consequence in the appeal court was, and it was a split decision. What is the effect of that? And what I'm taking the court to is Lord Justice Bean and what he said about Fixin. Now, my lord, I don't intend to read it, unless your lordship wishes me to do so.
No, thank you.
The actual section in Fixin is reproduced at 241, page 241, at paragraph 42. That's the most recent, up-to-date edition, the 20th edition. It still is. And your lordships will see what is said in general. A party is required to challenge in cross-examination. So, turning to the next page, at paragraph 43, Lord Hodge considers, I am satisfied the statement in Fixin is correct, and explained below summarises a long-standing rule of general application. Moving on to 248, paragraph 61, reaffirmed by Lord Hodge, from a review of the case law, it is clear there's a long-established rule as stated in Phipson. And on to the next page of 249, paragraph 70. The general rule in civil cases, as stated in Phipson, is a party is required to challenge by cross-examination the evidence of any witness of the opposing party on a material point which he or she wishes to submit to the court should not be accepted. The rule extends to both witnesses as to fact and expert witnesses. That, however, is not a universal rule, and Lord Hodge laid out 7 exceptions, starting at paragraph 61 on page 248. So I would refer to 61, 62, 63, 64, 65, 66, 67, and 68. The one I would like to pause on is at paragraph 67, sixthly. One of the exceptions is where an expert has been given a sufficient opportunity to respond to criticism of or otherwise clarify his or her report. For example, if an expert faces focus questions in the written Civil Procedure Rules Rule 35.6 questions of the opposing party and fails to answer them satisfactorily, a court may conclude that the expert has been given a sufficient opportunity to explain the report, which negates the need for further challenge on cross-examination. So what we say, of all the 7 exceptions to this rule, this is the only one which might have a bearing. And actually it doesn't have a bearing because that's not what happened in this case. What happened in the case was a report was prepared jointly, then questions were invited and granted by both parties, and it was in light of those questions that brought up the controverted or uncontroverted evidence, and no application was made to ask further questions or indeed call the witness for cross-examination. So there was a deliberate choice by Castlewater after the questions, I will go to them shortly, after those questions, in which the evidence that came out from the expert was not controverted, and following 2E, it is uncontroverted evidence, and therefore it prevents Castlewater inviting the judge not to accept the evidence in in those answers. That is the extrapolation and application of the ratio in 2E to the facts of this case. Now, the slight confusing issue here is that 2E in the Supreme Court had not been decided at the time that the Deputy District Judge Ginesi was considering this. So she was working with 2E in the Court of Appeal, where the door was still open to invite the judge.
Oh, was she working with 2E at all?
She was.
She was. Let me just see where.
Let's have a look at
where she has.
what she said at Core Bundle 193.
193. Thank you.
Sorry, I don't want to mislead. She doesn't reference 2E as a case, but as we'll see in this passage, she was coming to the same application. So 74, paragraph 74, please. And this is in her judgment.
Yes, so it's paragraph 74, which
No application was made.
Yes,
under,
we don't have to read it out, but that's where she deals with this particular issue. And it was only that I hadn't remembered her referring to 2E. She didn't, but no doubt you would say that this is very 2E compliant.
very compliant, yes.
Her approach.
In fact, when one looks at the last sentence, it puts the claimant in a difficult position. It was a difficult position at the time of 2E in the Court of Appeal, and it would be surely a near impossible situation or position to be in after 2E had been decided in the Supreme Court. Now, what we say is, in light of that, we have to look very carefully at A, what the expert was instructed to do, and B, what the expert actually did, and C, the evidence that the expert gave in these answers. And that's what I want to take the court to now, if I may. And I propose to move quite quickly through that. So the starting point is the supplementary bundle at page 2. This is the letter of instruction dated 19th January 23. And just in the second paragraph, I draw the court's attention to an order that had been made by the court on the 30th of August 22.
Yes, what page are you on?
Page 2.
Thank you.
So I'm referencing an order made by the court where permission has been given for parties in this action to rely on the jointly instructed written evidence of an expert in the field of mechanical engineering water meters on the issue of the accuracy and working conditions of the water meters with particularly meter number 1 recording water usage. Now, presumably that was a matter of agreement between both sides at that point for that order to be made. Turning to page 7, we get to what he's actually asked to do. Page 7, letter D for Delta. You are instructed to prepare a report and provide an opinion as to whether A, the water meters recording consumption at the defendant's premises are currently and or are likely to have been previously functioning as expected, whether an occurrence of either or both meters malfunctioning, slipping, is possible, and see whether or not the readings produced by the meters can be relied upon as accurate for the period 2017 to 21 and ongoing. So this is the content that the parties are fixing the experts with. So it's a bit of a rum lot to then criticise the expert later by saying they have overstepped the mark by looking at slipping or historic or past readings, or indeed the dials and the accuracy for the period, when indeed this is what he was instructed to do. Now, let's see what he did. 15, please. This is his report. If I can go through this quite selectively, for my purposes, I want to take the court firstly to page 33. And paragraph 3.2.0. Just simply to note that the expert properly identified the 2 relevant regulations to be applied here in light of the instructions that he'd been given. Turning to page 41 and paragraph 5.2.0. Now, it's at the lower section here. There's a sentence, increase has been assessed as plausible. It's the next sentence I want to take. Moreover, page 41.
Yes.
5 point.
Page 41. I was just giving your lordship the paragraph number,
Yep.
but it's over the page. And I'm taking your lordship to, is that 6 lines up from the bottom? The sentence beginning moreover. Moreover, during April 2020, the UK was already into a COVID-19 induced lockdown, which casts even more doubt on the increased estimated usage. Turn now to page 42 at 3.2.3. And this is where he explains issues of limescale. I'll let your lordships read it. But in big picture, it is where a device is enveloped with scale. It's lime, iron, and manganese. Builds up over time. It can interfere with the indicating device. A build-up of scale can lead to the device advancing 2 digits instead of 1, which can cause a device to advance by 11 instead of 1, and so on.
I didn't quite understand the next sentence. I mean, I physically didn't understand what it meant, and it's my inability, but it would help me if you could explain what it meant. The lower down the scale the operation occurs, the more frequently it might occur.
I think by virtue of the way the line scale builds up on the meter dial, the numbers at the nearest end to the water ingress, so if we imagine hundreds, tens, ones, 0.1s, it's at the 0.1 side of the meter that the water ingress, as I understand it, is more likely to happen. And therefore, what he's saying there, the lower down the scale the operation occurs, the more frequently it might occur. The lower down the scale, as I understand it, 110, 1.1, etc., it's more likely to turn. So, in essence, I think what he's saying here is the hundreds are less likely to turn as doubles than maybe the 0.1s or the ones.
That's what I thought, but then I thought, well, that's odd, because he's used the word scale to refer to the thing, the gunge, I would call it.
I misread that as well initially, my lord. He's using scale as a shorthand for line scale.
But that means you're more likely to turn the lower number, so you'll have 11 instead of 10, but not a million instead of 999,000.
One might have thought he was asked about that in the questions.
He wasn't, yeah.
All right.
Yeah, he wasn't. Anyway.
So that's what it means, yeah.
Right.
And you've seen it happen once.
He'd seen it, yes. And he tested hundreds of meters. Can we go now to 43, please? 5.3.0, where he considers possibilities, because he is saying he has to answer the questions that have been put to him. We've looked at the questions put as to accuracy or inaccuracy of the meters. Therefore, he says, I need to consider how a failure might have occurred or whether the readings provided are likely to be an accurate record of the water used.
I mean, 5.26
Yes.
above puzzled me, because this is a situation where somebody's relying on this evidence to prove that the that the meter is registering properly. It says there are large gaps in the readings,
Yes.
and it's not possible to ascertain with any certainty that such an event has occurred. It's also impossible to rule it out. That seems to be what he's saying, isn't it?
But he's seen it. Yeah, be clear about that. Previously on meters, I've been prompted that it's not these meters. That's right, he doesn't say that. But he says he has seen it previously on meters.
If the burden of proof is on you to show that if you're allowed to go outside the meter registering and not having been tested, it not to be working, if you can't ascertain with any certainty, aren't you stuck then?
Yes, we are. Yes, yes. Well, we would be, wouldn't we? Because it's our opportunity to prove. We see.
You don't have to prove certainties. You don't have to prove certainties.
No.
Sorry?
You don't have to prove certainties.
No. On the balance of probabilities.
Yes.
Yeah. Yeah. And one way, of course, would be to commission an expert report from somebody with this degree of experience and expertise to comment on it.
Anyhow, I mean,
Yes.
we have the report, and you take us to other parts that you consider significant. But I mean, the general tenor of the expert's report was that he didn't know what was wrong, but he thought that something he thought that something was or might be wrong, but he couldn't identify what it was.
That's exactly right, my lord. And therefore, it prompted the Part 35.6 questions, which is what I want to come to.
Right, good.
That's absolutely right. So page 115, please. Sorry, that's the starting point of the questions. I want to go to 117, please. And his answer to question 5. It's a passage beginning, both meters were within. Sorry, I should have made this clear. These are Castle Waters questions. That's where I wanted to start. Castle Waters questions, part 35.6 questions, my fault. And lower down, sentence where he says, I cannot confirm that evidence will or will not exist within these meters. However, we also cannot rule this out. Now, what he's addressing there is wear and tear within the meter. And as he comes on to, he says these meters have to be removed and dismantled carefully to see what is wrong with them internally, both as to wear and tear, and also, as we will see, in terms of limescale ingress. I want to go now to 119, please. Question 8. I think it's over the page, in fact, 120, where he was asked if the meter model was the same manufacturer model of meters we tested in this case. Yes, this has in fact occurred.
Sorry, I've lost what you did. You're in number 8, which starts at 118.
Yeah, what I've done, my lord, is give you the starting point, 8, which is a way back. Where I'm going.
Right. Okay, but this is a question about his limescale, the limescale paragraph that we looked at earlier. That you were asked questions about the scale, the lower down the scale. So that's the same question, same passage he's been asked about.
Yes. Let's find that.
You see that?
That's absolutely right, my lord. Halfway
bottom
down,
of 118.
C. That's right. That's exactly right. At C, this is what he's asked about scale. Please confirm if there was any evidence of the meters being enveloped with scale at the time of the site visit on 10th February 23 or on testing. And he says, as previously answered, until we have permission to open the meters up for a thorough internal examination, we would be unable to answer this question due to the limited time scale we've had to work with. We did not put this idea forward.
Just be very slow. What do we get from these questions that you've looked at? What are they?
Well, this is the evidence that's coming out from these questions, which, my lord, is not controverted. So all of this evidence, we say, is available to the judge Ginesi.
Right.
You have the point.
Right. Anything else on the questions?
Yeah. Just 1 to 5, please. Question 13.
Question number.
It's bundle 125 at question 13. And he is asked by Castlewater, considering both conclusions reached, do you think that the meter readings can be relied upon as an accurate record of the water usage and its properties?
So which conclusions is this a question about?
This is their question. I've moved on.
Yeah, this is a different, this is completely different.
Yeah. My apologies, I've moved on to our questions. These are our questions. So let me, sorry, my apologies. Question 13 is our question. We asked that question, and the short answer is no.
Yes, but sorry, I'm just trying to understand which both. It says considering both conclusions reached. Can you just give me the cross-reference to the conclusions to which that refers?
I would hazard a guess that there were 2 meters and there were 2 readings, and the reference to both is to the meters.
Yes, but, sorry.
Yeah. But let me check. I don't immediately know.
Is it a reference to a conclusion reached by him in his report? Both conclusions reached. I don't know what the conclusions reached. What's it a reference to?
It's a fair question, Lord. I don't know the answer to that. We'll find out.
Right. Well, you'll have time to look into that before we finish the hearing.
Yes. Just want to have a look at one last question by B&D, question 17 on page 125. Please, can you clarify and expand what is meant by problematic? And he says he means him as expert, are referencing the meter that has the unexplained vast hike in readings. He, the expert, considers this is a suspect meter, and he, the expert, finds the meter readings hard to specify and understand. So this was evidence elicited from the part 35.6.
Right. So the question really is whether that does it for you.
Indeed.
In the statutory sense.
Indeed.
Right. Or whether, more properly, in relation to an appeal, whether the trial judge was entitled to find that you had discharged the burden upon you.
Exactly right.
Yes.
Exactly right. Can I go to what the trial judge said about this? The starting point is core bundle at 186.
I'm sorry, I was still trying to get the...
Core bundle 186.
I'm sorry, my lord.
No, I was just passing on a reference. Right, so we start with the second issue, do we? Paragraph 20.
Paragraph 20, which is 186. I'll let your lordships read that. Then, if I can take the court to 187, please. I propose to move quite quickly here, if I may.
Yes.
Paragraphs 24 to 28 for reference are discussion of the single joint expert evidence. On the uncontroverted evidence at 187, please. Paragraph 28. She repeats the short answer is no passage.
Yes.
Turning to paragraphs 29 to 34 at 188. She systematically works through the expert's possible causes of the defects, all of which is uncontroverted and open to her to accept. 191. At paragraph 62, please. She assesses what her function is. The court has to decide on the balance of probabilities, and she divides it to defect and non-defect reasons. Now, I think she's criticised for that, but that is how the expert had approached it. And
does she say anything about the burden of proof?
I think she is coming to that paragraph 17.
Sure, she may have done, but
yeah.
I'm...
She has already, and then paragraph 70, Lord, 192.
Sorry?
192, please, at paragraph 70. she records the joint experts.
I'm sorry,
Sorry?
I'm just
Yeah, yeah.
this may be pedantic, but I'm trying to just work out whether in the paragraph you say it's criticised at paragraph 62, whether that is what the court had to decide.
Your Lordship asked me about burden of proof, which we find at paragraph 58.
58, that's what I was.
Yes. Sorry, I've jumped.
There we go, thank you.
So she has put it in context, framed it,
58 and 762 together.
and then goes on to the findings that she's made on issue 2. Sorry,
Yep.
issue 2. Make that clear. At paragraph 73, 193, bundle reference. This is her assessment of the opinion evidence of the single joint expert. She accepts some of the comments are suppositions and not based on actual evidence. There was no actual evidence of scale, wear and tear or debris. Nonetheless, such comments are that a joint expert, that of a joint expert, which carry considerable weight. And we say she was entitled to come to that view. At 76, she says, I find that taking into account the joint expert's comments, so taking into account, it's not a wholesale adoption. And reading on, the vast inference is, and on the balance of probabilities, it was more likely than not. And she continues at 77. That she finds, as a matter of fact, that it's more likely than not that the water meters were defective for a number of possible reasons, and references the joint expert. Something is not right, and there's something untoward. And she concludes more at 78, I'm satisfied that the defendant has proven on the balance of probabilities.
So the finding is one of transient defect.
Yes. To conclude, I want to have a look at what...
I mean, that's not, a point taken, it's not actually accurate, is it? I mean, as I understand it, you showed us at page 125 of the supplementary bundle, that something's not right, but it's something untoward with one of the meters, not both.
Yes.
Is that right?
Yes, that's fair.
So was it defect in the main meter? Is that the point?
Yeah, I mean,
There's a looseness there.
yeah, at 77, it says, as the joint expert has said, he cannot prove for certain what has happened at this stage, but in his view, something is not right and there is something untoward with the meters. Now, in fact, what the expert said is, the short answer is no. We can't. When asked, do you think that the meter readings can be relied upon as an accurate record of the water usage of the property? He says the short answer is no. We cannot prove for certain at this stage what has happened. However, it is fair to say something is not right, and in our opinion, there is something untoward with meter ending in 6-4.
Meter 1.
Meter 1.
It's meter 1.
Your Lordship is quite right to take to make that point, and actually 78 is a repetition of the same error. I'm satisfied, she says, increase in recorded users in meters. That's a looseness of language. That is a slip. We accept that. That should be meter 1. That should apply it. Now,
So does that mean that she said that you had to pay the invoice for the reading for the other meter, but you didn't have to pay the invoice for the reading from meter 1, or did she order you to pay order?
no, I don't think we ever got there.
We never got
It
there.
was when it went to appeal and then was sent back for the calibration in terms of regulation.
Can I just understand, these are 2 meters,
Yes,
they're on, are they on separate import,
Yes, they are.
separate
I understand it, yes.
supply
Yes.
inserts?
This is a statement that's incorrect. Yeah, meters is not right. It's a slip. It should say meter 1.
And I haven't checked.
There was
it
no
through.
issue between them.
I haven't checked it through on the invoices, but the invoices show the meter readings for the 2 meters separately, and it's because the spike you refer to is only on one of the meters, not both. That's what I'd sort of understood, but yeah.
That's it.
As I understood, meter 2 supplied a certain number of the properties on this industrial area, but they were separate properties from the ones supplied and recorded by meter 2.
And therefore a separate account. In
Yes.
So from memory, and this may be completely wrong, the meters were installed at the same time.
I think they were, my lord, yes.
They were installed at the same time, and so the conclusion.
2006, I seem to remember.
Yes,
2002?
there was
There
a
were different times actually.
No,
Or
there
there were
was-
different ages.
They were different ages, but they were installed at the same time.
Yes.
And there was a typo, I think, in relation to one of the installation dates, which threw us off at some point. But anyhow, they were installed at the same time, and the conclusion is that one was unobjectionable and the other was transiently faulty.
That's it. So to conclude, I want to have a look at what His Honour Judge Simpkiss did with all of this.
Yes.
And why I say he misdirected himself. And the starting point is 119. Paragraphs 44 to 54, he deals with the second ground issue. That's for the court's reference. 44 to 54. Now, the first point to note is His Honour Judge Simpkiss, like Judge Ginesi, did not address TUI at all. But he had been told about the case, and he had been told its effect. Now, I say that because my predecessor put in a skeleton argument, which can be found at 161 core bundle, where this was done. So he was drawing to the appellate court's attention the reported decision of TUI in the Supreme Court and the effect of it. And the court will see at 161 the response to submissions.
Sorry, where's the...
Top of 162.
Sorry.
My lord, what I'm referring to is
Yeah.
the skeleton argument
Yeah.
that G&D put in before the appeal
Yeah.
to His Honour Judge Simpkiss. And my point of taking the court to this is to show that it was put in front of the court what TUI said and what the effect of TUI was. And my position is that after that he actually did nothing with it. But here's the evidence of that. Ground Roman 3 at the bottom of 161 is the starting point.
Yes.
Reading on to the top of 162.
Yeah.
And then on to paragraph 33. Someone will give me a bundle reference there. 173, please. Paragraph 33. In the skeleton, ground 2 is a criticism of the judge's acceptance of the expert's evidence. This is an extremely difficult position for C to adopt, given post-Griffiths, TUI, in the Supreme Court, as noted by the judge at paragraph 74. In the preceding paragraph, the judge, I'll let the court read that.
The thing about the expert's opinion in this case was that it really came to the fact that something's wrong, but I don't know what it was.
Couldn't put his finger on it, and therefore gave a number of possibilities from which the court would be entitled to draw as an issue of probability what was more likely and less likely.
Yeah, I mean, to be fair to the expert, what he said was, I can't tell you, something's wrong. I can't tell you what it is without being allowed to take the meter
Destroy it.
apart. And I would need to be allowed to take the meter apart to tell you what it is.
Definitively, yes. Yeah,
Well,
so he's engaging with possibilities, isn't he?
Yes, well, that's one aspect of it. He said it would be difficult to do and so forth because all the limescale would fall out. you're not careful. And the other aspect of it was asking the expert to give an opinion about all the other non-meter related possibilities.
He was asked that, and he himself, as an expert, would have to be careful to stay within the realm of his competence.
Well, quite.
But it was a legitimate thing for him to answer if he was asked the question.
But why did he say that he thought something must have gone wrong? I mean, wasn't that based upon his
expertise and
well,
his
is it? I mean, his expertise is in relation. Is it? I mean,
Water meters.
Just water meters,
Water
or?
meters and
But I mean, I'm just trying to understand where in his report, and you didn't take us to it, where in his report does he actually ground the conclusion that something must have gone wrong?
Other than the section I've taken the court to, where something untoward and something.
But he says at 125, it's that sentence in his report where he said, well, sorry, it's not at 125, it's in his actual report. It's his actual report. It's I mean, his conclusions are at page 46 of the supplemental bundle. That's why I asked you what the question related to that you took us to. You took us at 125 to the answer, which seems to have everybody's been focusing on. Question 13, which says, considering both conclusions reached, and I asked you, well, what are we talking about there? And the place you find his conclusions is at page 46. And as far as I can see, his conclusions are those at 602. I mean, that's his conclusion, which is that both the meters were within the tolerance band and past the accuracy limits. And the question I thought was in relation to that, considering both conclusions reached. Now, I suppose it's possibly in relation to the two water readings.
I think that's right. I think his conclusions
It might be 603. That's the second conclusion.
That one, the meters passed the test, and two, the meters faulty.
Okay, so meter, then it says meter 64 is the meter that exhibits problematic readings.
Faulty they might be faulty in other ways. Doesn't mean it can't be faulty in other ways, and they're problematic readings. But I'm really struggling with what the expert is doing in relation to these other matters. I can see that it's useful to have an expert to tell you that it takes 600 days or something like this of a tap left running to create a certain amount of metered usage and those matters. But it's not really a matter for the expert to offer an opinion about whether it's likely that people were in or not in during COVID, or people were having extra people on site or something of that sort. That's not really what the court needed somebody for, is it?
No, I'd agree with that.
It's to explain how water meters work and to give technical information about the
meters and the performance.
The water system.
Occupation and even one view leaks, maybe not viewed within the.
But in the end, the judge had a much better view of the evidence as a whole. But we have the expert's report, just as she did, and the answers. And so she didn't gain from oral evidence. And the question really comes down to, as it seems to me, is whether there's something funny here, I can't put my finger on what it was, is sufficient for your purposes.
Or maybe reframed, these are distinct possibilities that I have seen and I have expertise in, and I'm experienced engineer in this field. I can't prove it without destruction, of the meters, but everything is pointing.
No, I was really referring more to the in the field matters. I wouldn't for a moment disagree that he was entitled to say, I have got experience of having been, as he puts it, lucky enough to see a meter jumping.
Yeah.
I mean, the one thing, going back to the first question, something this way comes question, something untoward. It seems to be 520. It's the fact that there's such a large discrepancy between the amount of water that's been used before and what is happening in these three readings. And he says it's around 2.5 times more than previously. And he's saying, gosh, if you're using 2.5 times more than previously you've been billed for, that raises a query. And then he says, it seems, I've tested the meters and there's nothing wrong in terms of the meters working, but there might be other things. I've once seen a meter do a double somersault,
Yes.
and also there are other things.
Yes.
And he goes on to say, and I don't think much of the leak of the COVID things, particularly having regard to the factual evidence of others. That seems to be the thrust of the way his report goes.
Taken in the round. That's right.
Yeah. That's the way
Taken
it
in the round
goes.
is the key there. So there's no smoking gun here.
No.
But there's a lot of circumstantial evidence. And it is whether
Yes.
he's entitled to draw these inferences from that evidence to come to the conclusions he comes to, and indeed, whether the court thereafter is entitled to rely on the balance of probabilities.
Well, one could see that if he drew attention to something that was a commonly encountered problem with water meters,
Yes.
that he had experience of instances in the past where it had been shown that they simply weren't working correctly, unexpected spikes were down to undetectable faults and so forth.
Landscape.
But it's not that sort of evidence. Right. So now you were in the judge's.
Yeah, I'm almost there.
No, you were in the judge's judgment about this, weren't you?
Well, I was about to go through what Judge Simpkiss
Yes. Starts at
did
44.
with that. Now, core bundle 119.
Yes.
At paragraph 46. I'll let the court read that. First observation, it might be it wasn't for her to explain the untoward nature. It would be a matter for her whether she accepted it or whether she did not. At 120, paragraph 52 and 53. To clarify, it was not her finding that there was a spike. It was admitted between the parties that there was a spike. And thus, I'll let the court read what he said about her judgment ultimately being sufficient for a judge to make a finding in reaching the conclusion she did. We say he was wrong in that. And the reason for that is what he does here has to be measured against Volpe grounds, the Volpe and Volpe case. I've already referred to the sections we rely upon. And to conclude, if we could turn that up, please.
Can I just, before you do it, at the risk of going back, would I be right in thinking that what's happened here is that you've got an expert in who's a water meter expert. He's faced with a spike accepted between the parties to have occurred. He says, in my experience, spikes like this are the result of either something wrong with the meter or, to put it bluntly, somebody leaving a tap running or a leak or something like that. he's an expert in water meters, obviously in the context in which they are used, but his actual report says, when I tested these water meters, to the extent I was allowed to, I didn't find anything wrong. He then goes on to say, but in my opinion, something is untoward here. Something is wrong. When asked a question in light of that, but that seems to be based upon his own view of the other evidence about the use of the premises at the time, during COVID and other evidence, which it might be said is not actually for him to. It might be said not actually really for him to express an expert opinion on, because it's not in his area of expertise. So
the question becomes maybe, to what extent can the expert find facts upon which he bases his opinion?
Well,
and on Kennedy against Cordia, that is a function that is permitted.
Well, I'm just trying to understand what your TUI argument is, because I understand that if you have somebody who's expressing what I got as a true expert opinion, and if you don't challenge it and controvert it, you can't then be heard to say, but it would ask the judge to say it was wrong, because it's within a matter of the expert's actual remit.
Yeah.
But if what the expert is doing is saying, well, I've done what I was asked to do as an expert, I've tested the meters, they're accurate now, but in my view, something must have gone wrong otherwise. Isn't that really for the judge to say?
That is. And so what we're saying about TUI is the language used in the report is that somebody is generally bound to accept the evidence if it is uncontroverted.
Well, the expert evidence.
Yes. But we don't go that far. That would be to usurp the judicial function. That cannot be right. What it actually means is they are precluded, they're closed off from inviting the judge to not accept the evidence, is the first point. But the second point is on TUI, that it is still for the judge to interrogate.
Yes,
that
but it's properly offered expert evidence.
Yes.
But the whole TUI issue
Yes.
falls in the context of expert evidence properly so called. So, for example, if Castle Water wanted to say that 400 tankers of water doesn't represent the amount of water that was lost, they would have to take that up with the expert.
Yes.
But they can't just substitute their own estimate.
Yeah. So TUI only takes it so far.
Yes, right. Well,
After that, we're into the realm of
right. Okay, but
judicial function.
I'm just trying to go back to the paragraph my Lord Justice Lewis referred you to at 5.2.0, at page 41 of the expert report, where the expert says, after criticising the large gaps in the meter readings, Castle Water had not kept proper records for and the like. And then he refers to the meter readings, and he says there's a 2.5 times increase in April 2020, which is during the pandemic, and he says indicates an implausible monthly usage of 2.5 the apparently previously confirmed usage. No indication why this increase has been assessed as plausible. So, is that an expert opinion he's entitled? Is that an expert opinion he's entitled to express, that it's implausible, or is that for a judge?
Does he have the expertise to express an opinion on plausibility? Is it an opinion on plausibility?
Yes.
Yes. Maybe
No.
not.
No.
But that doesn't collapse the whole house of cards into
No, certainly not.
report. It's not a paradigm report. There are slips and failings, but we are. I just wanted to conclude with Volpe and the parts of Volpe I took the court to before, because ultimately I see that Judge Simpkiss should have applied the Volpe to this.
You're basically, your point as I understand it, is that his paragraph 54, which is the only point at which he says this is not good enough, is not good enough to satisfy his obligations
In a
with regard to Volpe.
in a nutshell. In which case, I'm quite happy to leave the court with the parts of Volpe, and Volpe I've already taken
Yes.
the court to. What I say, to be clear, is applying those to the present circumstances. There's not enough here for His Honour Judge Simpkiss to interfere with the decision of the court.
I think unless you want to return to them, you made clear your position in relation to ground 3 when we were dealing with it at the beginning.
I will leave that down.
All right. Well, if there's anything at 2 o'clock that you realise as soon as we rise, you simply had to say, you'll of course have the opportunity to say it, but otherwise, Mr. Parrott,
We'll do the
also,
homework as well.
thank you very much.
I'm clearly going to be very pressed for time, and I don't want to presume, but I do have some schedules just giving some extracts from the expert evidence. I sent them to my learned friend yesterday.
Very well.
If you would
Well,
find that helpful.
Well, we'll certainly, if you think we might, well, then we'll take them now. Thank you.
So I've got 3 sets of 3 schedules. Hopefully that will cut down the amount of time I need for my oral presentation. Thank you.
And do they all go to the reports? If I take
Yeah,
the
that's
report,
exactly.
I don't need it. I'm not going to get the discover. I should need another file then. Okay.
No.
Thank you very much. Well, we'll resume at 2:05.
Court rises able.